We have 12 questions today that we're going to be answering. We had over 120 attendees on Zoom today. That is amazing. Thank you so much for being here. So let's get right into our questions. The first one is, who enforces Arizona state statutes? Our association fine policy is in conflict. It allows 21 days to respond to the violation, but assesses fines after 14 days. Okay, so first part of that is who enforces the state statutes. So if the association is seeing a violation and, they can enforce the violation either by going to the Arizona Department of Real Estate and making a claim for an administrative law judge to hear the matter, or going to Superior Court to have a judge make a decision on it, or recording a lien. We have that right. But also homeowners have that right. If they're not happy with how things are being run according to what the law says associations are required to do, the association definitely has that right to, the association owner definitely has that right to sue the association, go to the Arizona Department of Real Estate to have a administrative law judge look at the situation. Even really just contact the board and say, hey, I think you're violating the law, and see what kind of a response you get. Okay, our association fine policy is in conflict. It's hard for me to comment on it without actually seeing it. I know that you're saying that you have 21 days to respond to the violation, but the fines are imposed after 14 days. I haven't seen it. There is a law that gives an owner 21 days to respond on violations. But there's also a law that said, and there's a specific procedure to do that, whereby they have to, put it in, a certified letter and have that certified mail return receipt requested. But as long as the board has complied with that law and already given all the information regarding the violation, often, they've already provided the 21 days, to give the information about the violation that the law requires. And if they give notice and opportunity to be heard, they could assess the fine after 14 days if the timing on that is right. So if the initial letter complies with all aspects of the violation letter that you're required to have under the law, you give the owner notice and an opportunity to be heard, and then you levy the fine, on the 14th day after the notice and opportunity to be heard, it could be okay. I haven't seen your fine policy, so it's hard for me to comment on that.
Thank you so
I
much.
agree. It does sound like there's a conflict. I think you need to look into that a little more, but there would be a workaround on that if they structured it right. Okay, next question. Let's see. Where do we go? All right. Scroll all the way up to the top. Sorry about that. Okay, the second question here is talking about the beneficial ownership information reporting program of the Corporate Transparency Act. This is actually kind of a hot topic right now among community association attorneys. I've discussed this with a number of different groups that I belong to. So we're all talking about, does the Corporate Transparency Act apply to associations or not? So we know that this law applies to the question saying this law applies to corporations with less than 5 million in assets, fewer than 20 employees. You're making the statement that you think community associations are not exempt, and reporting requirements are going to be implemented January 1st, 2024 with a January 2025 deadline. And so you're wondering, how is this going to work with associations, right? Well, first, you indicated in your question, you have a very long question, so I had to kind of summarize it, that Community Associations Institute, that national think tank that I told you about, has taken the position that this act was not intended to apply to community associations and is lobbying for an exemption. I agree with that position. I don't think that this is something that was intended to apply to, HOAs and condominiums in Arizona or any other state. A lot of this deals with, like terrorism money, and is,
Thank you so much.
notifying people, corporate directors, so that the federal government can keep track of it. I just don't think that this is something that ultimately is going to be determined as being something that applies to as far of a reach as a nonprofit HOA or condo board in Arizona. But I agree right now, the way it's written, it does appear to apply, but stay tuned because I'm not sure that by January 2025, it will not have been clarified by our federal government. Okay, question 3. Can you comment on the mandatory federal registration of Arizona community associations in 2024? So that's the exact same question as number 2, talking about the Corporate Transparency Act. Just again, in conclusion, I think that by the time that the reporting requirements go into place with the January 2025 deadline, that this is something that is ultimately going to be clarified that doesn't apply to associations. So stay tuned. CAI, which is the national think tank that represents, millions of owners and associations, they are working diligently to try to get this clarified so that it doesn't apply to associations. But stay tuned. Promise you, it's going to be a hot topic that we're talking about in 2024. And we don't have any actual reporting requirements until January 1st, 2025. So try not to get too overly concerned and upset about it because it's not totally done, right? There's probably going to be some clarification legislation on this. And we're not the only industry. Many other industries are also asking for clarification. So it's very likely going to happen in 2024. Okay, next question, number 4. We are a self-managed HOA. What voting methods would you suggest we use to elect new board members? Who should oversee the collection and the counting of the ballots? Is it acceptable for the ballots to be collected at a board member's home? So lots of questions regarding annual meeting, election of board members, and you're self-managed, so you're trying to do it all on your own. Okay, so what voting method would I suggest? I would suggest using absentee ballots and send those out in advance of the meeting. They have to be sent, at least 7 days, I believe, before the meeting. It's either 7 or 10 days before the meeting. So factor that in. Who should oversee the collection and counting? If you are worried about it going to a board member or there's been a concern about that, send it to your CPA, send it to your attorney. We frequently collect ballots on behalf of associations and count them for them. And that is, something that we can do. Is it acceptable to have them go to a board member's home? It's unusual, I would say. But when you're self-managed, what are you going to do? You don't have a PO box for your association. That may be the only option. What I would recommend if it does go to a board member's home is that you don't open them until the night of the meeting and then have independent persons who are not running for the board count them.
Thank you so much. Thank you so much.
Next question, number 5. Does our HOA need to list the names of the members of the architectural committee, or can the architectural committee remain confidential? Our board would like the names to be confidential because historically, homeowners have harassed them to the point where they have dropped out. If their names are not confidential, we will not have a committee. Our
Thank you so much.
documents do not specify anything on this. Our management has told us that legally their names cannot be confidential. I agree with your management company. They can't be confidential for a number of reasons. Number one, we have to designate these people every year as the architectural committee, right? And so the minutes should reflect who's on the architectural committee. Secondly, there should be minutes of these architectural meetings or minutes of their decisions. And, people have a right to know who's on the architectural committee. So I 100% agree. If there's litigation, it's going to come out who's on the architectural committee. So I 100% agree they cannot be kept confidential.
Thank you so much.
Okay, next question. Number 6. Our bylaws state that the board president needs to have served on the board for 1 year. What do we do if no board member qualifies? That's a really weird provision to have in your bylaws. So you may want to amend that. Look at how to amend your bylaws and take that out because I've been doing this a long time, almost 27 years. And, from my perspective, that's
Thank you
a
so
weird
much.
requirement. I don't see that very often. In fact, I hardly ever see that, maybe like less than a handful in 27 years. So what do we do if no board member qualifies? So amend your documents, would be one thing, or just move forward because if no one qualifies, what are you going to do, right? I mean, you can't bring in somebody else. I suppose in theory you could bring somebody back to the board, but I don't know exactly how this is worded. But I would just move forward on it and amend your bylaws because that provision seems so like that is not realistic and not very common in our industry. Okay, question 7. What are your thoughts on ElectionBuddy e-voting for board annual elections? A postcard was emailed once with voting instructions with Zoom annual meeting. I'm okay with this. I think that there should be more than one communication though. So if your board is going to be using e-voting, I think that there should be a publicity blitz that, okay, this is how our annual meeting is going to be conducted this year. It should be on your website. It should be in several communications to your owners. You should be talking about it at board meetings. There should be follow up with people who haven't voted prior to the vote being taking place. My experience with e-voting, using companies that work with HOAs and condominiums for e-voting is very positive. Like we have a way higher turnout than we have without e-voting. Now, recognize, like I said earlier in the presentation, if people don't want to participate in e-voting, that's okay. Give them a back door where they can request a ballot and vote that way. Okay, next question, number 8. If the CC&Rs are silent on an issue, does the board have the right to set the rules?
Thank you so much.
That's really hard for me to answer because I don't know what your CC&Rs say about your rulemaking authority. Is it broad? Does it allow you to make a rule on this particular issue? So generally speaking, I'm going to have to give you a general answer. So, if your documents are silent on it, absent broad rulemaking authority by the board, you probably cannot pass a rule on something. But if you have broad rulemaking authority, check with your attorney to see if that's something that you can pass a rule on, to supplement what the CC&R say, because it's not in the CC&Rs, but it's within the realm of the broad rulemaking authority. Okay, question number 9. If a family member rents a property, is this handled the same way as a rental with the county and with the HOA? That is a good question. So you have the landlord saying, well, it's just my family member staying here, right? If money is being exchanged, this is considered a rental that they would need to register with the county and the city, and they would have to pay the $25 fee that we talked about earlier in the presentation, set up in the Condominium Act and the Planned Communities Act. Lots of times, though, when it's a family member, they just say there's no money being exchanged, and it's really hard to prove, that there is money being exchanged. So it's kind of a pickle for the association to enforce that.
Thank you so much.
Question number 10. What is the process for filing a lien on a property owner for legal fees attached to HOA ARB violations? I think maybe that'd be like HOA. I think it's Airbnb violations is what they mean. So we can only record a lien on a property in Arizona in a condominium in a planned community if the owner owes past due assessments, legal fees incurred regarding the past due assessment, collection costs regarding the past due assessment, or late fees. So our firm, because the state law doesn't allow us to do this, we do not record liens on a property for a violation fines that may be incurred. So, like renting their property is an Airbnb in violation of the association's documents. We're not liening for that. We can only lien, like I said, for assessment related legal fees, collection costs, late fees, and the actual assessments that are owed. Okay, next question. What is the let's see. Next question, number 11. Can we amend the CC&Rs for short-term rentals? How do we factor in this hallway case? That was decided in 2022. Okay, really great question. So, if you look at our cheat sheet on rentals, which we shared with you earlier in this presentation today, we talk about the fact that state law was amended several years ago, and it said that if an association wants to implement a rental restriction, they need to place it in the association CC&Rs through an amendment, right? So we have state law,
Thank you so much.
statutory law saying if you want to implement a rental restriction, you got to amend your CC&Rs to do that. Okay, and that law was passed, 5 or 6 years ago. Now we fast forward to 2022, and the Callaway case is decided by an appellate court in Arizona. And it basically says that any amendments that we do have to be foreseeable and reasonable, and the court can use a blue pencil and strike through anything that they don't think is reasonable and foreseeable. And so we're balancing this, right? So it appears from the Callaway case that, like, hey, doing amendments that aren't reasonable and foreseeable, like, that's problematic under this case. But then we've got this state law that says, hey, if you want to implement rental restrictions, you have the right to amend your CC&Rs to do it. So, it's a gray area. That's the bottom line. It's a gray area. So some associations are moving forward with it, knowing the risks that they could be sued under the ruling in Callaway. The appellate courts in Arizona haven't ruled on this yet. We're cautiously proceeding on these. And if your association wants to do this, reach out to me. We'll show you how we're cautiously proceeding to limit liability and to make sure we don't get sued. So one way to do it is to grandfather, so that it only applies to new owners, and the new owners can't sue us because they, purchased knowing that there was no rentals or whatever the situation is. And so there are ways to do it cautiously. Just you got to evaluate it and learn about the risks. Okay, next question, number 12. So we have 3 more questions. Can you remove the board if it is owned by the builder? So it sounds to me like you're under a declarant controlled board. And unfortunately, it is very difficult, if not impossible, to remove a developer controlled board. What I would recommend is for you to take a peek at our cheat sheet on, construction defects and issues with developers that we have on our website. And take a peek at that, because it sounds to me like you've got developer issues, right? That's why you want to remove the developer board. So checking out that, cheat sheet is going to give you some suggestions on where the most common problems with the developer and what you can do as a homeowner waiting for the developers to leave, right? And to get off the board and turn it over to the association's owners to run the board. I think the name of the cheat sheet is Transition from Developer to Owner Control. So bottom line is you likely cannot remove the developer from the board. And you've got to come up with your strategy. You may need to, have the group of like-minded owners, consolidate and form a group to try to hire your own lawyer to go after the developer for any problems that they may be causing. Okay, second to the last question. How long are property management companies required to keep records for communities? Our HOA would like to gather old records from the company we ended our relationship with back in 2019, and also the one before that ended in 2017. So bottom line here, when you ended the relationship, that was your time to get the records, right? They should have turned over all of the association's records to you at that time of transition to the new management company. So going back to them now, I'm very doubtful that they're going to have those records. You can try, but I'm doubtful they're going to have them. How long should you as an association keep the association's records? We have a great cheat sheet on this topic. It's called Association Records Retention. It's on our website, mulcahylawfirm.com. Just go to our cheat sheets, type in keyword records, and it'll pop right up. There's different, so it's a sliding scale. Some records we keep forever, like CC&Rs and other association documents. Some things and minutes we keep forever. Some things we can throw out after 6 years. Why 6 years? Because there's a statute of limitations under a breach of contract of 6 years.
Thank you so much.
So I encourage you to take a peek at that cheat sheet, because it'll give you a definitive answer on what documents you should keep and for how long. Okay, last question for today. Is our previous management company required to give me, a homeowner, copy of invoices they paid for our HOA? So I think that the key word here is previous management company. So, your former management company, they have no obligations to your board or your association. At the time of transition, they should have turned over all records to the association's board and the new management company.
Thank you
If
so
you
much.
want to get a copy of an invoice that was paid for your association, you should go to your current board and make a records request. And if they still have it, they need to provide that to you.
Thank you so much.
I don't know what kind of invoice it is. If it's an attorney invoice, they may have to redact it because there might be some confidential legal information in the invoice, but regardless, you would be entitled to see that invoice. A few things I want to mention as we close out today is that we have some additional free learning opportunities that are coming up here in the future. First things first, we had over 120 live viewers on Zoom and Facebook Live today. So thank you so much for the great participation and for being here today. So don't forget, Friday, November 3rd is our next virtual First Friday free call-in where I answer questions for free until all the questions are answered. Additional details on this can be found on our website. Questions can be submitted now through the morning of November 3rd at 8:45 a.m. And then we go online on Friday, November 3rd at 9 and answer every question that's submitted. Last but not least, we're starting to get into the holidays. And so in November and December, we have a few changes to the classes that we're teaching. So first things first, in November, instead of having our virtual HOA Academy the third Tuesday in November, we are having it the second Tuesday in November so that we don't interfere with any turkey making and family outings and travel plans of people who might not be able to attend. So in November, our virtual seminar is going to be on Tuesday, November 14th. So the second Tuesday of November. And we have a great class. We're going to be talking about how to be a successful association and what are some qualities of A+ board members. So that's going to be a really great class for you to attend. Lastly, please consider leaving our firm a Google review. We are sharing a link in the chat right now on how to leave a review. We are always happy to get feedback about these classes and how we're doing as a firm so that we can continue to provide these classes to you and continue to provide interesting subject matter and change up our format if you don't like something, or if you're really happy about it, it helps us because then we share that information with the cities that we're partnering with and they see the value of these classes. So we want us to continue doing them. So giving us a Google review, letting us know how we do will be shared with them and we would very much appreciate it. So thanks everybody for being here today. Happy Halloween. Don't forget that all these new laws that we talked about today, the 5 new laws, go into effect the day before Halloween on October 30th. Looking forward to seeing you in November and at future events. Thanks again for being here today and have a great weekend. Bye.